Well, hello, everyone, and welcome to another virtual classroom session. My name is John Bowens, broadcasting here from the Equity Trust virtual classroom. And in this segment, we're going to be talking all about estate planning and how this fits into your overall self-directed IRA or Roth IRA investment strategies. We're also going to share with you how the Secure Act has impacted inherited IRAs. And lastly, I want to talk a little bit about some strategies or tactics that can help you as an individual investor better plan for your legacy. You'll hear some people refer to estate planning as legacy planning. Now, all of that being said, before we move ahead into what we're going to be talking about in this segment, I want to make sure everybody's understanding that Equity Trust isn't here to provide tax, legal, or financial advice. This is for information and educational purposes only. Our clients here at Equity Trust invest in a wide array of alternative investments, from real estate to mortgage notes to trust deeds to private securities to cryptocurrency to gold and silver, just to mention a few. If you're an investor that's interested in real estate or other types of alternative assets, and you're looking for ways to leave a legacy of those assets to your children, grandchildren, or other loved ones, you're absolutely in the right place. But we encourage you to work with your estate planner, your CPA, or your other tax professional as you structure the right estate plan. I also encourage you to share this video with your CPA or your estate planner. In fact, I have taught hundreds of thousands of wealth managers and family office practitioners and CPAs and other financial professionals all across the country. So share this content with them, along with our other videos that you can find on YouTube. All right. Number one, we're going to talk about IRAs and probate. We're going to talk about the difference between a spousal IRA and a non-spousal IRA. See, it's different. When you leave your account to a spouse, it's treated differently than if you leave it to a non-spouse. What about the estate tax exemption? That was one of the questions that many folks had coming into this video training is, how do IRAs fit into our overall estate plan? How does this impact the estate tax exemption? We'll talk about that. We'll also talk about the Secure Act changes. So in 2020, there were some major changes to retirement accounts. It was called the Secure Act. And we're going to talk about one facet to the Secure Act, which is how this impacted inherited IRAs. Last but not least, Roth IRAs and inheritance. So what does it mean to inherit a Roth IRA? And what you're going to learn is a Roth IRA can be a very powerful savings vessel for estate planning purposes, because the Roth IRA is an after-tax account. It grows tax-free, and you can leverage what I call compounding interest in the absence of taxation. All right, so with that being said, let's drill down. First, IRAs in probate. This one's an easy one. Question comes up, John, when I pass away and I leave my IRA to a spouse or non-spouse, does this have to go through the court system, the court probate system? And the answer is no. So as long as you set up the IRA properly, you're working with the right financial institution, your IRA will avoid probate. So what does that mean? It avoids probate. It goes directly to the individuals that you've appointed to inherit your IRA. Now, you got to make sure when you set up your self-directed IRA, you appoint a beneficiary, and you want to make sure on an annual basis that you go in with your financial institution that you open your IRA with. If it's Equity Trust, when you open your account, it's easy. When you fill out your application, you're going to appoint a beneficiary. Every year, you can go online through our online system and update your beneficiaries as you see fit. But you want to make sure that you list a beneficiary. Now, for most people, they're going to list their spouse as their 100% primary beneficiary. And then you can list contingent beneficiaries. So if something were to happen to you and a spouse at the same time, you would have maybe your children or your grandchildren listed as contingent beneficiaries. For some people, if they don't have a spouse, they might list their children or grandchildren as primary beneficiaries, or maybe they list even a non-family member. Maybe they have a friend or other loved one that they want to leave their IRA to, or a lifelong partner they want to leave their IRA to. That's okay as well. Now, in some other training, we get into trusts. So if you have a see-through trust, a conduit trust, or an accumulation trust, so as long as it meets the qualifications, you can potentially leave your IRA to a trust. And then that trust has beneficiaries, and there's a trustee, and then they execute upon the powers granted to them of that trust. Now, that gets into a little bit more technical details. We're not going to go too far into that. Most people don't list a trust as a beneficiary to their IRA. Typically, we see them listing their spouse, and then from there, listing their children or grandchildren. Now, natural persons, the account being left to versus a trust, that really depends on your situation and also can depend on the investments that you have in the account. We'll get into that in just a second. Now, how do you know whether you should list your spouse and children or list a see-through trust, list a trust to the account? This would be a good question for your estate planner, your tax attorney, or your CPA, because they're the ones that really have the intimate knowledge and understanding of the full scope of your financial situation to determine what makes the most sense for you. But the takeaway from this training is you can list spouses, children, other individuals as beneficiaries, which is most commonly done, or you can list a trust. So as long as it meets the qualifications, a see-through trust, you might hear it referred to as a conduit trust or a accumulation trust. All righty. Now let's dive into the next component that we want to make sure we talk about, which is the spouses versus the non-spouses. All right. When you leave your account to a spouse, that account will be, in most cases, known as what is called a treat as own. Treat as own. What that means is the account becomes the spouse's account. It's almost as if it was always their account all along. It goes into their name. They can consolidate it with their other IRAs. They can keep it as a separate IRA. That's entirely up to them. All right, that's for spouses. You then have non-spouses. So when we say non-spouses, just think maybe children, grandchildren, other loved ones. If a non-spouse inherits an account, it becomes an inherited IRA, also known as a beneficiary IRA. So the titling of that account will actually have the individual inherited the account and your account. So it'll be known by financial institutions, whether they transfer it to another account, another company or not. It will always be known as an inherited IRA. And the reason why is because inherited IRAs follow different rules than a spousal inherited IRA. Remember, spousal inherited IRAs can be taken as treat as own. So the non-spousal IRA is really important to understand for two main reasons. Number one, when you inherit an IRA, even though you might be under the age of 59 and a half, so you'll hear this age 59 and a half come up quite frequently. That's the qualified retirement age. If you take money out of a retirement plan prior to 59 and a half, there's a 10% premature withdrawal penalty and ordinary income taxes on the growth. So with an inherited IRA, you'll learn that even under 59 and a half, you can take money out without this 10% penalty. Now, depending on whether it's a traditional IRA or Roth IRA, will depend on whether you're paying taxes on the withdrawal or not paying taxes on the withdrawal. We'll talk about that in just a second. But just remember, with an inherited IRA, you can start harvesting, you can start taking money out immediately without this 10% penalty. All right, the second item that's really important to understand goes to the Secure Act. So I mentioned that I'll talk about the Secure Act, so let's dive into it. The Secure Act was passed in December of 2019. It went into effect January 1 of 2020. Now, the Secure Act covered a number of facets as it relates to retirement accounts. But as it relates to today's specific session, we're talking about how the Secure Act impacted inherited IRAs. So first, let me explain prior to 2020. So prior to 2020, if you inherited an IRA, whether it was a traditional or Roth IRA, you could take the account out over your life expectancy. You would follow the IRS published life expectancy table. And every year you would have to take out what is called a required minimum distribution. In some cases, if you're younger, it was a very small percentage, like 3 to 4%. And then as you get older, you have to take more and more out. You hear people in retirement account planning call these stretch IRAs, where you stretch it out over your lifetime instead of taking it all out or taking it out within 5 years. In 2020, January 1 of 2020, under the Secure Act, those rules changed. Now, with an inherited IRA, you have to take the money out within 10 years. Now, there are a couple exceptions. We're not going to get into details on those. But by and large, you have 10 years to take the money out of the IRA if it's an inherited IRA. Now, remember, if it's a spouse, they're going to treat his own, so they don't have to worry about this. But non-spouses are going to have to determine what's going to make the most sense for them, because they're going to have to exhaust or take all the money out of the IRA within 10 years. Now, what's interesting about this is when they passed the law, they got rid of the required minimum distributions for those 10 years. So you don't have to worry about taking any money out for the 10 years. But once you get to the 10-year mark, you got to take all the money, all of the assets out of the account. Now, let's give you an example. Traditional and Roth IRA. So for those of you that haven't seen some of the other training, check out the difference between a traditional and Roth IRA. A traditional IRA is tax deferred. You put money in, you get a deduction. When you take the money out, you got to pay taxes. The Roth IRA is the opposite. You put money in after tax. It grows tax-free. When you take it out, you don't pay any taxes. That's going to be very important. In just a moment, you'll see. So let's say you grow a traditional IRA to $1 million and you leave it to, let's say, one child. Okay. So it's not a spouse, it's a child. So it's an inherited IRA. And they have this traditional IRA. And let's say they don't take any money out. And then at 10 years, they're forced to take a full distribution. They take a $1 million distribution. Because this is a traditional IRA, that $1 million is added to their ordinary income. And then they're going to have to pay taxes based on their ordinary income tax rate. So could you imagine that? They take a $1 million distribution. That's going to put them at the highest tax bracket. So at the recording at this time, it's 37%, but it could potentially go up to over 39%. So you can imagine this could be a rather large tax consequence for an heir. So if they do take all that money out, they would have to make sure they put aside a significant amount of that, call it 40%. They would have to make sure they put that aside to pay for the taxes. Now, they may not take the $1 million out at 10 years. They might break it up over multiple years. So maybe they take $100,000 out every year for the 10 years. So they spread their tax burden out over that 10-year period. But ultimately, if you leave an IRA to a non-spouse, inevitably it's going to happen eventually, right? You're going to want to make sure you do some planning so that you can optimize the tax situation for those beneficiaries. All right, that leads me to this Roth account. Now, let's say that prior to you passing away, you converted all of your assets and cash into a Roth IRA. This is called a Roth conversion. We have another video training on that. Or maybe you were fortunate enough to just always have had Roth IRAs and that's the only retirement plans you had. So remember, the Roth IRA is seeded with after-tax dollars. So you get the taxes out of the way. It grows tax-free. And then when you're in your retirement years over 59 and a half, you take money out and it's tax-free. For your children or grandchildren, when you pass away, it's tax-free to them as well. It avoids probate like we talked about. They can take all the money out. It doesn't hit their 1040 as ordinary income. It's tax-free. So when I talk about compounding interest in the absence of taxation, the Roth IRA is an incredibly powerful vehicle that allows investors to achieve that compounding interest in the absence of taxation. And imagine, for those of you that are investing in real estate, mortgage notes, and trust deeds, and you're making a very attractive rate of return through your own efforts, the Roth IRA could potentially be highly advantageous for you. All right, so let's say we take that same scenario, $1 million in a Roth IRA, we grow it to, we'll say $1 million, we pass away, we leave it to a child. That child doesn't have to worry about that 10 years. They don't have to worry about when they're taking money out, how they're taking it out. They can continue to allow that Roth IRA to grow for 10 years. And ultimately, that's what they'd want to do, right? You'd want to encourage them to continue to invest in real estate, mortgages, or whatever else it is that you're doing in that account, continue to grow it tax-free. And then when they harvest it in 10 years, there's 0% tax. It's never added to their ordinary income as taxable income because it's in the Roth IRA. So you can imagine this Roth IRA, like we've been talking about, can be incredibly powerful. But of course, let's not discount the power of a tax-deferred IRA, which of course grows tax-deferred over your lifetime. All right, so very important to take away that Roth IRA. That leads us to the last item, which is this estate tax exemption that I promised I would address. Estate tax exemption. So as of the recording of this video, the estate tax exemption is $11.7 million. And that would be for a single individual. Married couple would be 11.7 times 2. So you'd be upwards of over 22 million in exemptions there. So the question is, are IRAs added in that estate tax amount? And the answer is yes. So you wouldn't need to make sure you address that. Now, remember, IRAs avoid probate, so a lot of benefits there. Roth IRAs even better. You leave it to the child or grandchild. But if you had non-IRA assets in the amount of, let's say, 5 million, and then you have IRA assets in the amount of 5 million, your total would be 10 million. So you'd still be okay because you'd be under the 11.7 million, right? So you don't have to worry about estate tax. But if you, let's say, had 10 million in IRAs, and then you had, let's say, 10 million, or no, let's say 20 million, okay? Let's use 20 million in non-IRAs, that gives you 30 million. You're way over the 11.7 times 2 if you're married. So then you would have to pay estate tax on the amount over that exemption. Now, I mentioned at the beginning, right, that really important to have your CPA, estate planner involved, right? Estate planning and estate tax exemptions are very specific to the individual. You're also going to need to drill down to the state level. Does your state have estate tax? All right. But the important takeaway in today's program and answering the question that our viewers were asking is, are IRAs included in that estate tax exemption? And the answer is yes, they are. But remember, the IRA avoids probate. With the Roth IRA, you can leave assets in cash to your loved ones tax-free. All right, last but not least, quick bonus session for everybody. Viewers were asking me about, John, if I'm going to leave alternative assets like real estate to children or grandchildren, multiple children or grandchildren, what should I consider? All right. So there is one school of thought that you'll hear of where investors will open an IRA, and then when they pass away, they leave that IRA to a trust. And that trust is then made up of many beneficiaries. Could be 20 beneficiaries, could be 30 beneficiaries, right? Could be all the children, grandchildren, so on and so forth. Now, that trust has to be properly structured. It has to meet the qualifications to be left in an inheritance situation from an IRA. A see-through trust, you'll hear it referred to as a accumulation trust, or also known as a conduit trust. All right, so you'd work with your estate planner or CPA and get them to sign off on you leaving your IRA to a trust. Now, I will say that in most instances, investors do not leave IRAs to trusts. They leave their IRAs to their spouses, and then from there, they leave them to their children or grandchildren. But if you have a circumstance that warrants leaving the IRA to a trust, might make sense for you, just make sure you talk to your estate planner or CPA about that. All right, that leads us to, what if you have multiple properties in your IRA? How do you organize this? How do you set your heirs up for success and ease and simplicity? So many of our clients, so many of the people that I work with want ease and simplicity. So if you want ease and simplicity in your life and your beneficiary's life, this is what you'll want to pay attention to. All right, let's use this example. Let's say I have a Roth IRA and I have the, let's say, plan to acquire 4 rental properties in that Roth IRA. And let's assume I have 4, let's call it grandchildren. Maybe I'm getting up there in age and I really want to start planning for my grandchildren. So I'm going to actually skip over my children and leave this account to my grandchildren, which you can do, generational skipping. So here's what I do. My Roth IRA, I set up with equity trust, self-directed. I put some cash in there from another IRA. Maybe I convert from a tax-deferred account, and I go out and buy a property. And this Roth IRA, I name grandchild 1 as the primary beneficiary. And then maybe I list grandchild number 2 as the contingent beneficiary in case anything were to happen to grandchild 1. Now I have that property. It's going good. I buy a second property. All right. So second property comes online. Instead of buying that second property under the Roth IRA number 1, I open up a second Roth IRA. So I got Roth IRA number 2. I buy property number 2, and then I leave the account to grandchild number 2. All right. Now property number 3 comes online. I open up a third Roth IRA. I buy property number 3 with the third Roth IRA, and then I leave that property to grandchild number 3. Now, why would I do this instead of taking all 4 properties, bundling them up in one IRA, and then leaving them separately, or leaving them not separately, but leaving them all to the 4 grandchildren? Why would I not do this? Ease and simplicity. It goes back to that. If I pass away and I leave one Roth IRA to 4 grandchildren who were all listed as beneficiaries to the Roth IRA, 25%, 25%, 25%, 25%, here's what's going to happen. Each of those grandchildren will have to set up separate Roth IRAs, and then the properties will have to be deeded as tenants and common owners, 25%, 25%, 25%, 25%, which means if one grandchild wants to sell, the other 3 are going to have to agree to it. You could potentially create conflict in the family if you do this, right? So in this circumstance, instead of creating more complexity as well as more legal fees, what investors will do is they will leave individual properties and individual accounts to individual children. It could be, again, grandchildren as well, like in the example that I just provided. Now, this may not just go for real estate. This could be mortgage notes and trust deeds. This could be private securities. This could be precious metals like gold and silver. It could be cryptocurrency, right? Just plug and play any alternative investment that you might be looking into. So this was a practical approach to estate planning, Roth IRAs, the Secure Act. I hope you got a lot out of this session and content. Leave your comments below. If you have questions, leave those as well. We'll get back to you. If you are interested in opening a self-directed IRA, getting started with Equity Trust, check us out at trustetc.com or check out our other YouTube videos. You can find us very easily. Until the next video training, and we look forward to seeing you on the next video training, keep leveraging compounding interest in the absence of taxation. Thank you.